Well, good afternoon, everybody, and welcome to the last in the series of bite-sized webinars discussing counterparty risk. Today's seminar is on jurisdiction and commencement of arbitration and will be given by members of our shipping team, namely Alex Bramwell, who has recently been promoted to partner, together with associate Connor O'Brien. In terms of housekeeping, and in order to keep the quality as good as possible, I would be grateful if you could all mute your microphones if they're not already muted, and please turn off your videos as well. If there are any questions you would like to put to either Alex or Connor during the course of the presentation, could you use the text function in Teams, please, which is the speech bubble icon on the Teams toolbar. At the end of the presentation, I'll direct any questions received to Alex or Connor to respond to. Please be aware that the text function can be read by all participants in the seminar, and we'll be recording the presentation so it can be listened to by others in the future. Of course, if there are any questions which occur to you after the presentation is completed, you please feel free to contact Alex or Connor direct at any time. Now I'll hand over to Alex, and I hope you enjoy. Thank you.
Thanks, Tony. So as Tony said, we are going to be doing this seminar on jurisdiction and commencement of arbitration. We're going to focus today on four, I suppose, key issues to provide a quick practical session, and hopefully you can take something valuable away from that. So we're going to talk about why does it matter, and part of that is what goes wrong and what are the consequences when commencement of arbitration isn't done correctly and or potentially out of time. We're going to talk about commencement in compliance with the terms of the contract, and then touch on some of the institutional requirements, and then also what sits behind all of that, and that being the Arbitration Act 1996. We'll go through some of the, I suppose, key bits of case law, some of which is relatively recent, just to provide some examples of what the courts have decided does and does not constitute good service, and also how they are treating potential service out of time. And then lastly, we'll just finish on some practical takeaways and a bit of a shopping list, which will hopefully give you something to take away to check and use next time you are commencing arbitration, which lots of people are doing on a regular basis. Okay, I'm now going to hand over to Connor, who's going to start us off with why does it matter?
Thanks, Alex. Good afternoon, everybody. As Alex says, we thought before we dive into the case law and some of the more practical points, we thought it might be useful to put this into a bit of context and consider why this matters and why it's so important. After all, there are claims handlers, in-house lawyers in private practice that commence proceedings on a very, very regular basis. But the reality is that things can go wrong, and they do go wrong. And as we'll see, there can be some serious consequences. We've got 3 points up there on the slide, sort of a sliding scale of seriousness, if you like. The best case scenario, if things do go wrong, are that you're going to have wasted time and costs in commencing proceedings. In those circumstances, hopefully you should simply be able to recommence proceedings, pay the relevant arbitration fees, and crack on as you normally would. That's not always the case. I recall very recently we inherited a claim in which the respondent had failed to appoint their arbitrator within the 14-day time period. They subsequently sought to do so, and this was challenged by the claimant. Both parties had to put in submissions, and the arbitrator had to issue an interim award. It took a couple of months for that to happen. It also cost the losing party about £15,000 in legal fees and arbitrators' fees. Now, obviously, that's not a hugely significant sum, but it's sums that don't need to be incurred, particularly when you're not looking at the substantive merits of the case. A slightly more serious issue arises when you miss the time bar. It's not at all unusual for proceedings to be commenced towards the end of a time bar period, sometimes even on the last day. In those circumstances, if you get things wrong, you may not be able to bring your claim at all. And on the very fast scale of the most serious consequences of when things go wrong, and this is usually when parties don't engage in the proceedings, when the respondent simply stays silent, you may well commence proceedings, serve your claim submissions, obtain an award, and seek to enforce the award, and only then the respondent may raise the point that you haven't actually commenced properly. And in those circumstances, it may actually be the case that the award can be set aside. You may have wasted significant costs. You may then have missed the time bar as well, and then you are really in trouble. So those are some of the things that can go badly wrong. Hopefully now we're going to look at how we do things right. So first and foremost, what constitutes commencement? Can you simply appoint an arbitrator? The answer to that is no. In order to properly commence, you need to serve notice on the other party in writing, requiring them to appoint an arbitrator or agree to the appointment of an arbitrator within a specified period. And that's section 14 of the Arbitration Act. It's also reflected in the LMAA terms, which, as we know, are frequently incorporated into charter parties. It is worth noting that the Arbitration Act does make provision for party autonomy, as is often the case in arbitration, and it is open to the parties to specify within the contract how they wish the commencement procedure to work. But as we know, with the rough and ready nature of fixture recaps and negotiations between brokers, that's not very high up on the list of priorities, and it's very unlikely to be the case that it's going to be specified in the contract. So, constituting commencement, we have to serve a notice. What does serving a notice mean? Again, it may be that there are express provisions within the contract. It's not often the case. We're not dealing with a ship finance contract where you have specific provisions or you have a process agent appointed. Very often you'll have the details of parties, but you won't have relevant contact details. You'll then need to work out how you're going to affect service. When we look there at the provisions of the Arbitration Act, and this provides that where there's no express agreement in the contract, a notice or other document may be served on a person by any effective means. The Act, unfortunately, doesn't go on to specify in detail exactly what constitutes a person and what constitutes effective means. What it does go on to say is that any document or notice that's addressed, prepaid and delivered by post to a company's registered or principal office will be treated as effectively served. Obviously, the Arbitration Act was 1996. We now live in an age where it may not necessarily be the norm to be posting things. Emails are quite often the way forward, but the Act is silent on that, so the case law has had to fill that in, and we'll look at that very shortly. Just before we do, the most important thing to do, obviously, when you're looking to commence proceedings, is to check the arbitration clause and the specific provisions. They may well incorporate institutional rules. They may simply be silent. But as we know, there can be a wide range of provisions. You might have something very detailed like the BIMCO dispute resolution clause or the MEBA clause. You might simply have a very brief sentence in the recap specifying arbitration in London. And it's worth checking very carefully what the provisions in the contract say, what the provisions of the Arbitration Act say, and what any institutional rules say. One of the things to note is the number of arbitrators. Obviously, you'll be limited usually to a sole arbitrator or 2 or 3 arbitrators. The standard forms often specify the number of default arbitrators where it's not expressly stated in a recap. And there are also provisions in the LMA terms and the Arbitration Act where the details aren't specified. Briefly, just going over those, in the LMAA rules, the default provision where the contract is silent is that there'll be 3 arbitrators, 1 to be appointed by each party and the 3rd to be appointed by the 2 so appointed. There is also then provision for what is to happen if one party fails to appoint and notify the other party of their appointed arbitrator, and that you fall back there on section 17 of the Arbitration Act, which requires you to give 7 days notice that you're going to be appointing your arbitrator as the sole arbitrator. It's just worth noting here that the 7 days is 7 clear days, and it doesn't include weekends and bank holidays. So you might be tempted where you serve your 7-day notice on a Monday to then notify the other party the following Monday, but just be careful because that wouldn't be the case, and you would be commencing prematurely. There are also provisions in the LMAA for when there is to be a sole arbitrator and when the respondent fails to agree the sole arbitrator. In those circumstances, either party can apply to the LMAA for an appointment of an arbitrator. That's a very simple, very quick procedure. Alex and I did that a couple of weeks ago. You simply pay the administration fee of £350 and the president of the LMA will then appoint a sole arbitrator. Things are slightly more difficult when you're dealing with the Arbitration Act. If the LMAA terms aren't incorporated, the fallback position in the Arbitration Act is that a sole arbitrator will determine the dispute. And in those circumstances, it's for the parties to jointly agree on a sole arbitrator within 28 days. Where a sole arbitrator can't be agreed, you'll then need to go to the court to appoint. It may also be that the arbitrators need to have specific qualifications, so do check the clause carefully for those. It may be that they need to be a member of the Baltic Exchange, engaged in shipping or carrying on business in London. So it's worth just checking those points. And the final point on this slide here we've got is multiple contracts. It may be that you're dealing with circumstances where parties have engaged, they've entered into a charter party, there's been disputes and they've tried to resolve things commercially. They may have entered into an interim agreement or a form of settlement agreement. And it's not always the case that the arbitration or jurisdiction provisions in each of those contracts marries up. So it's worth checking each of those to make sure that you're commencing properly under each of them. And obviously, if you can, appoint the same arbitrator to determine any and all disputes. The other point on it is if you're dealing with a string arbitration, something like a bunker quality dispute, and you've got head owners, charterers and sub-charterers, it makes sense to try and appoint a common tribunal in order to minimise costs. So those are some of the things to look at when you're commencing proceedings and checking the arbitration provisions. We're now going to look at some of the points on service and what constitutes effective service. And the first case we're going to be looking at is the case of the Eastern Navigator. This was a case in 2005. The charterers failed to engage in the proceedings at all until the enforcement stage. And they then raised a Section 68 application with the court, which is an application to set aside the award on the basis of a serious irregularity. And the facts of the case were this, that it was the solicitors that had served the notice. They'd sent it via email, but they'd sent it to an address that had not appeared in any previous communications with the charterer and didn't appear in the charter party. However, it did appear on the Lloyd's Maritime Directory and also on the charterer's website. In that case, the judge, in looking at the case, he compared the service provisions with those of the CPR and said that you weren't looking at the same. You didn't have the same considerations here. The court requires that if you're going to be serving via email, it either needs to be agreed between the parties or provided for in an order. The judge made the point that the parties engaged in litigation and the purposes of the CPR, you may be dealing with very, very competent businesses with experienced lawyers, but you may also be dealing with individuals with no lawyers, and that's why the provisions of the CPR were so stringent. But he said that the dealing with arbitration is a slightly different situation, and you're dealing with usually business to business where both parties have ready access to lawyers, and he held that there's no reason why email should be regarded as any different to a communication by post, fax or telex. The other important consideration here was the use of the email address. The charterers had put this on their website, and the judge held that they'd held it out to the world, that this was how to communicate with them, how to contact them, and for that reason the Section 68 application failed. The next case to look at is the case of the Lake Michigan. This was an application to extend time under Section 12. For those that don't know, Section 12 deals with the court's ability to extend a time bar in circumstances where it would be unjust to do so. And the facts of the case were this, that the owner was incorporated in Barbados, had its principal and registered office there, but it also had registered offices in Hong Kong and the Marshall Islands. The owner's P&I club had been involved from the outset. They'd been involved in the giving of an LOU, they'd been involved in settlement negotiations, and they'd also been involved in granting extensions of time to the cargo interests for their wet damages claim. What then happened was the cargo interests served notices of arbitration. There were two separate notices. One was done about a week before the end of the expiry, and then a revised notice was served on the club on the very final day. And it was only on that day that the club turned around and said that they weren't instructed by the owners. They didn't have authority to accept service on the owner's behalf. So the cargo interest scrambled. They served notice on the owners in the Marshall Islands in their office there, but due to the time difference, they were late by 8.5 hours. So there were two issues to be determined in this case. The first is whether the club had authority to accept service, actual or ostensible. And the second issue was, if not, whether the cargo interests were entitled to an extension of time under Section 12. And dealing with the first of these issues, the court held that the position of the club was analogous to the position of a solicitor who is instructed on matters generally by a party. And that means that they don't have it, well, absent express instructions, they don't have authority to accept service of originating process. However, in the circumstances of this case and the role played by the club, they'd received the first notice of arbitration about a week before the end of the expiry and had stayed silent. And it was only on being served with the second amended notice on the very final day that they turned around and said they didn't have authority. The judge held that their conduct meant that it would be unjust to hold the cargo interest to the time bar, and the Section 12 application was therefore successful and an extension of time was granted. I'll now hand over to Alex, who's going to be talking about some of the more recent cases on service, starting with Sino-Channel Asia and Dana Shipping.
Thanks, Connor. So the next two cases that I'm going to talk about continue this theme of agency and service on the proper party or the proper person. The case of Sino-Channel v Dana Shipping related to a dispute under a contract of affreightment. Dana were the owners and Sino-Channel were the charterers. Sino-Channel had previously engaged another company, for the purposes of this talk, we'll call it Company B, to arrange the contracts of affreightments, but in Sino-Channel's name, and also then to handle the day-to-day operation of the contract. So Sino-Channel had no real involvement in the contract itself. It was all arranged, finalised and conducted by Company B. So a dispute arose and Dana served notice of arbitration by email on Company B. Sino-Channel did not take part in the arbitration, which is a common theme of the cases that we see, but it also means that the consequences, if it wasn't done properly, are much more serious. So Dana got an award in their favour, which was served on Sino-Channel themselves. Sino-Channel then turned round and said some 4 months later that they wanted to challenge the award and seek a declaration under Section 72 of the Arbitration Act, on the basis that Company B did not have authority to accept service. So Section 72 states that a person alleged to be a party to arbitral proceedings but who takes no part in the proceedings may question whether the tribunal is properly constituted. And Sino-Channel did that by stating that it wasn't properly constituted and therefore did not have jurisdiction to deal with the dispute because service of the notice was not properly given. So, what is authority? And what is actual authority? We look here at the case of Helly Hutchinson v Brayfield Limited, and Lord Denning, the famous Lord Denning, said that actual authority may be express or implied. It is expressed when it is given by express words. It is implied when it is inferred from the conduct of the parties and the circumstances of the case. Actual authority, express or implied, is binding as between the company and the agent, and also as between the company and others, whether they are within the company or outside it. So, Dana said they didn't argue that Company B had express actual authority because Sino-Channel had never provided that. They did argue that Company B had implied actual authority. They appeared to have been dealing with the matter and passed the notice, when they passed the notice to B, that he had actual authority to accept it. And even if that wasn't the case, they pleaded that Company B had ostensible authority, and that arose from a representation by the principal, Sino, that Company B had authority. All of those arguments failed at first instance, and that's despite the contract being constituted and finalised with Company B directly, and company B having full conduct of the contract throughout the duration of the charter. The courts drew analogies to, and it goes back to the Lake Michigan case, the clubs and also potentially solicitors, stating that a general conduct of the matter does not necessarily give a person or a party authority to accept notice of arbitration. It seems very strict. And then on appeal, sorry, first of all, we need to deal with ratification. So there was another question, because Sino Channel had waited 4 months before they challenged the award, whether there was any ratification by Sino Channel. So there wasn't a positive ratification because that requires an unequivocal act that Sino Channel didn't do. They didn't take part in the arbitration at all. It was also incapable of silent ratification. I think the important thing to be aware of with Section 72 is that there's no time limit. Unlike a Section 67 application and others under the Arbitration Acts to appeal an award that have a 28-day time bar, Section 72 doesn't have that. And Sino Channel were therefore able to challenge the award some 4 months later. And now we'll get on to the appeal. So I think it was Gross that dealt with the appeal. And he came to a different view. He stated that Company B did have implied actual and indeed ostensible authority. And that was on the background of general disinterest and passivity on the part of Sino Channel. Essentially, and as I've described, Company B enjoyed carte blanche in relation to the contract, including a potential breach. The next case is Glencore Agriculture v Conqueror Holdings. This was a charter party dispute concerning delays at a port. Arbitration was commenced by Conqueror Holdings against Glencore, and the notice of arbitration was sent to an employee of Glencore who were themselves dealing with the operational side of the charter party contract. However, Glencore, who took no part in the arbitration, this all came out at the end once the award had been granted, stated that the employee that had received the notice was a junior back office employee. So the question before the court was it service by an effective means, i.e. was the email to Glencore's employee who was dealing with the operational side of the charter party good service, or was it service on a party that had no authority? The court held that there was no service. I think that this is quite harsh, but it just goes to, I suppose, stress that service, even on a specific employee of the respondent company, might not be good service. The arguments, or the decision was based on the employee had wide authority to deal with, I suppose, the general operational side, but did not necessarily have authority to accept notice of arbitration. The court mentioned that the employee did not take part in the subsequent arbitration proceedings, but I don't really take that as particularly persuasive, given a company of Glencore's size would have a separate legal team, and they would take the conduct of it and wouldn't really involve somebody from the operational side. The third point was that the claimants could have made inquiries with Glencore as to who or which department should be the proper department to serve the notice. The last case is PVQ, QVR and RVS. Bear with me on this one because there's a few parties to it, but this is in relation to time bars and seeking an extension from of time from the courts on the basis that something occurred which was not within the contemplation of the parties when entering into, in this case, 3 sets of back-to-back voyage charters. So, as I said, 3 back-to-back voyage charters. However, there was time charter parties above. The time bar provision within the voyage charter parties was 13 months from final discharge of the cargo. The final discharge of the cargo took place on the 16th of October 2015. On the 16th of November 2016, so the last day of the time bar, the time charterers above the parties to this dispute, gave notice to P, the head voyage charterer, of a cargo claim and served notice of arbitration. And that was at 1844 on the 16th, so after business hours. P became aware of the notice the following morning on the 17th, so already out of time for effective service under the applicable time bar in the voyage charters. They informed Q of the claim, but didn't actually serve formal notice of arbitration until the 25th of November. Q were a little bit more savvy, and Q's legal team served notice on their subcharterer on the 17th, on the day that they found out about the dispute, albeit a day out of time. On the 30th of November, R, who had received the notice on the 17th, went back and said, "Oh, sorry, Q, you've only served via broking channels, and that isn't good service." Q then immediately served again that same day on the 30th of November, direct. R waited a while after receiving the initial notice on the 17th, which, according to the facts of the case, they actually received from the broker on the 18th. But they waited until the 29th of November to serve on S. So the questions to the court were, could the court declare that the notices were served within time? And if not, would they grant extensions? As we know from lots of the demurrage cases, the English courts deal with time bars very, very strictly. And the court was unwilling to make a declaration that the notices were served within time because they were not. The nearest one, if that was good service on a broker, which I'll come on to in the takeaways in a moment, was still a day late. So P, who served later on the 25th, their application was refused. 9 days was seen to be too long. Q's application was granted, and that was based on the service on the broker on the 17th, and then also the reserving on the 30th. Unfortunately, the court case doesn't, and the judge didn't actually decide on whether service on the broker was good service of itself or not. And I think with the issues and how strict the courts have been in relation to the agency point, I don't think necessarily service on a broker of itself would be sufficient. And then finally, R, who were the latest on the 29th, their application was refused as well. So I think the takeaway from this is that if you do receive information, albeit it might be outside of a time bar, but you get the information about the claim then immediately serve notice. Don't wait. Don't try and find out further information and think, oh, I'm out of time anyway. Serve straight away, because the court might be able to grant some leeway on the time bar in those circumstances. So that's it for the case law. And I just want to finish on, I suppose, some practical takeaways, a bit of a checklist of things to think about when you're next commencing arbitration. First of all, always check the specific wording of the relevant clause together with any institutional rules, and then also the Arbitration Act 1996, as Connor explained. Identify the service party in the contract. Not only just the company, but look at the arbitration clause itself. If we look at an example such as the ASBA tank void form, that requires service on an officer of the respondent company. Now, to me, the most appropriate person would be a director in that circumstance, but make sure that you've got the right service party. If you're dealing with lawyers and P&I clubs, or indeed potentially brokers, seek confirmation that they have authority to accept service. And if they don't, always aim to go directly to the respondent company. Dispatch the email address of the intended recipient. Be careful, especially if there are different departments. I use Glencore as the example. In that case, the court actually stated that if the email had been sent to the general ops team email address, that probably would have constituted good service rather than just a specific named person within the ops team. If you are serving via email, obtain a delivery receipt. you can obviously set that as a setting. Use high importance. Plaster all over the subject bar that this is a notice of arbitration, so it comes to their attention. And also ensure that the email doesn't get rejected. Connor and I, again, on one previous case, we served on a variety of email addresses at the respondent company, and one of them was their general email address. And that email was actually rejected because the mailbox for that particular email address was full. So be careful of that. I would recommend using multiple email addresses if possible. The more the better, in my view. And as I've said, broking channels alone, I'm not so sure would necessarily do, given the stringency of the agency requirements that the court has explained in the more recent case law. As I said, Sino Channel and Glencore 2017. And if in doubt, if you can't get an appropriate email address or you've got any concerns and you also have time, serve on the registered address and obtain confirmation. We've dealt with some quite recently via process server, as Connor has said. I think the Marshall Islands was one that we've done, and you can usually get a process server for a few $100 US to go and do it, and to do it very, very quickly. But be careful of the time differences, as Connor explained in one of the previous cases. So that's it. We hope you enjoyed the seminar, and you've also found it valuable, and hopefully you've got a bit of a checklist and some things to think about for when you're next commencing arbitration. Now I'm going to hand back over to Tony, and then we'll deal with any questions if there are.
Great. Well, thanks to Alex and Connor, and thank you for joining us on the series of counterparty risk. I understand that a complete set of the recordings will be circulated in due course, and please also look out for further seminars or webinars, seminars if we are able to do so, from us during the autumn as we build up towards London International Shipping Week in 2021. There are no questions, so I'll just say thank you once again for joining us, and hope to see you all soon. Thank you. Goodbye.